Good afternoon, everyone, and welcome to the webinar, Prosecuting Sexual Abuse in Confinement. My name is Charlie Whitman. I'm an Associate Attorney Advisor at Equitas, the Prosecutor's Resource on Violence Against Women, and I will be moderating today's webinar. This presentation is designed to provide prosecutors and allied criminal justice professionals with an overview of how to prepare for the prosecution of a sexual abuse in confinement case involving an adult victim by providing an understanding of common issues and barriers, including lack of certain evidence, proper interpretation, explanation of certain evidence, and witness unavailability. The issues and strategies that will be discussed are relevant for the prosecution of cases involving juvenile and other victims, as well as abuse that occurs in any confinement setting, prisons and jails, lockups, community confinement facilities, and juvenile facilities, although the latter will be addressed more in future prosecution-focused webinars that we'll be presenting in the coming months. Before we begin the substantive portion of our program, I will provide a brief overview of our iLink webinar service by answering 3 questions. 1. How can I listen via computer and or via conference call? I strongly recommend using our conference call line 605-475-4700, passcode 1003755#, and that you call in from a landline. That number is also located in the top left portion of your screen. If you are using a mobile phone, please do not use the speaker option. Listen with an earpiece if necessary. If your call gets dropped, please call back into the conference line as soon as possible. All call-in participants will be automatically muted throughout the webinar. For those of you joining the webinar via computer, utilize Internet Audio by clicking on the Connect button on your start screen. If you use this audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet audio. Second, how can I seek assistance if I have technical issues? If you have technical issues, use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. Please take a moment to locate the hand raise option. Use the hand raise option to show me how many of you are using Internet audio today. Great, thank you. Looks like a good number of you are, and I'm glad that you can hear us today. If you experience any technical difficulties, you may also contact iLink directly at 1-800-799-4510. Third, how can I answer and ask questions during the webinar? Throughout the webinar, questions will be posed to all participants. You can respond to questions in 2 ways. First, for yes or no or multiple choice questions, use the iLink feedback indicator located on the left-hand side of your screen. Let's see if you can answer a question. Have you previously attended an iLink webinar? If the answer is yes, you have attended an iLink webinar before, please click the button next to yes in the feedback window. If not, click the button next to no in the feedback window. I'll give folks a few minutes to respond. Okay, great. It's good to know. Looks like the majority of you have used iLink before. Second, if the presenter poses an open-ended question, you should respond via private chat to me. To ask questions or make a comment, use the same private chat option located on the bottom left-hand side of your screen. I am the only one who will see the questions and comments, and I will share them anonymously with the group. We encourage you to ask questions and post comments throughout the webinar that we will answer and address throughout the presentation and during the question and answer period at the end. If the presenter does not answer one of your questions during the presentation, please feel free to email her after the webinar. Her email address will be provided. Finally, if you would like to enlarge the content screen in iLink, you can minimize the chat window by clicking on the arrow box in the left-hand corner of the chat window. If you would like to reopen the window, please click on that same box again. Today's webinar, Prosecuting Sexual Abuse in Confinement, is hosted by Equitas, the Prosecutor's Resource on Violence Against Women, and the National PREA Resource Center, through funding from the U.S. Department of Justice, Office of Justice Programs, Bureau of Justice Assistance. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you after the presentation. The National PREA Resource Center was established through a cooperative agreement between the Bureau of Justice Assistance and the National Council on Crime and Delinquency. The mission of the PRC is to assist adult prisons and jails, juvenile facilities, lockups, community corrections, and tribal facilities in their efforts to eliminate sexual abuse by increasing their capacity for prevention, detection, monitoring, responses to incidents, and services to victims and their families. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. Equitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter will be Equitas Attorney Advisor Victoria Christensen. Prior to joining Equitas, Vicki served as a Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She also previously served as a Senior Attorney for the National Center for the Prosecution of Violence Against Women and as an Assistant District Attorney in Philadelphia, Pennsylvania. And now I'd like to turn the floor over to Vicki so that she can begin the substantive portion of today's webinar.
Good afternoon, everyone. Thank you so much for joining us on this lovely and, depending on where you're located, very chilly Friday afternoon. At the conclusion of today's presentation, you should be better able to prepare a sexual abuse and confinement case for prosecution, including understanding victim and offender dynamics and the significance of the presence or the lack of certain medical and other kinds of evidence. You should be better able to apply Crawford v. Washington and its case law progeny to a prosecution when a victim or a witness is unavailable for trial. And you should be better able to understand how the Prison Rape Elimination Act, also known as PREA, and the PREA standards may be relevant to your investigations and your prosecutions. Sexual abuse and confinement cases, as we know, can be very complex. And in the coming months, we're going to offer 3 additional webinars that address various prosecution issues, including pretrial motions, intimidation, and forfeiture by wrongdoing. Throughout the webinar today, we encourage you to submit any prosecution-related questions and comments or questions about PREA and the standards, the latter of which will be answered by Tara Graham, who is the Senior Program Specialist at the PREA Resource Center. A note on why today's webinar is going to utilize the term sexual abuse. It's because the PREA standards use this term to refer to most unlawful sexual touching and penetration. The standards define sexual abuse as contact between the penis and the vulva or anus, contact between the mouth and the penis, vulva, or anus, penetration of the anal or genital opening, and any other intentional touching, directly or through clothing, of the genitalia, anus, groin, breast, inner thigh, or buttocks of any person that is unrelated to official duties or where the staff member, contractor, or volunteer has the intent to abuse, arouse, or gratify sexual desire. So as you can see, this is a very, very inclusive definition. This slide contains a brief synopsis of the passage of PREA and the standards. So PREA legislation was passed into law in 2003, and 6 years after that, the National Prison Rape Elimination Commission published a report and draft standards. The final standards were released by the Department of Justice in May of 2012, and the following month, the final standards were published in the Federal Register. In August of 2012, the standards became applicable to the Bureau of Prisons, and later this year and into 2014, corrections facilities will experience their very first PREA audit cycle. what do we all know? We all know that the Prison Rape Elimination Act did not create a new crime. We know that sexual abuse is a crime no matter where it occurs. However, we have created the standards because of the serious negative impact of sexual abuse in confinement, and because for the most part this was not being addressed either in reporting, in investigations, or in prosecution. The Act also includes, and the standards also include, information directly related to prevention and reporting and reactions in confinement facilities. How prevalent is sexual abuse in confinement? How often is it happening? And thus, for us as prosecutors, how often should we be seeing these cases? And if you take a look at these statistics, you're going to immediately see that we are not seeing them in a manner that's consistent or at a rate that's consistent with their actual occurrence. PREA findings reported that at least 13% of inmates in the U.S. are sexually abused in prison, with many inmates suffering repeated sexual abuse. Since PREA was enacted, BJS, the Bureau of Justice Statistics, has conducted several studies on sexual abuse in various types of confinement facilities. BJS has found the following: 9.6% of former state prisoners reported one or more incidents of sexual victimization during their most recent period of incarceration. More than 75% of all reported staff sexual misconduct in state prisons involved male inmates with a female staff member. For former state prisoners, the rate of inmate-on-inmate sexual abuse was 3 times higher for females at 13.7% than for males at 4.2%. And 13.7% of male, 17.2% of female former prison and jail inmates reported a violent sexual inmate-on-inmate incident. As those responsible for seeking justice, we just simply cannot accept that these cases historically may not have been a priority in our various offices. The following few slides contain the case, the fact pattern that we're going to utilize for today's webinar. And as you'll see when reading this, this is absolutely a case that any of us could get on a phone call about or receive the discovery for, at least preliminary discovery for, tomorrow morning or Monday morning when we walk into our offices. On Thursday, November 8th, 2012, Victor Jones, age 19, reported an incident of sexual abuse to Corrections Officer Patrick Morrison, who then contacted the shift supervisor, Tony Gonzalez. Gonzalez interviewed Victor Jones, who revealed the following. On Monday, November 5th, Jones was transferred into a cell occupied by Kenneth Douglas, age 28, and 2 other adult males. The cell had 2 bunk beds across from each other, with Douglas's lower bunk directly across from Jones's lower bunk. The day after Jones was transferred, on Tuesday, November 6th at approximately 2 a.m., Jones was awakened by Douglas when Douglas put his hand over Jones's mouth. Douglas stated quietly, "If you say a single word, you'll be dead by morning." Douglas then forcibly inserted his penis into Jones's mouth and after a period of time ejaculated into Jones's mouth. Jones spit out some of the ejaculate onto the floor, which Douglas wiped up with his shirt. Douglas then pushed Jones onto Jones's bed, lay on top of him, placed his hand over Jones's mouth and nose, and his forearm over Jones's neck. Jones began to squirm because he could not breathe but was unable to get out of Douglas's hold. Douglas was nose to nose with Jones when Jones lost consciousness. The following day, Wednesday, November 7th, at 2 o'clock in the afternoon, Jones sought medical care for a sore throat and pain in swallowing. The physician on duty in the correctional facility noted in the medical records after examination the following findings: petechiae to the soft palate and tonsillar pillars, some generalized redness. And on Thursday, November 8th, after lunch at about 1 o'clock in the afternoon, Victor Jones reported the incident to Corrections Officer Patrick Morrison and then gave that statement, that summary statement that we just heard, to Supervisor Tony Gonzalez. So my question, our very first question for you is, do you think this case would be prosecuted in your jurisdiction? Use the iLink feedback option that Charlie talked about a few minutes ago, located on the left-hand side of your screen, to answer yes or no, whichever is more probable. Even if you think there's a 51% chance this case would be prosecuted, answer yes, and Charlie's going to share the results with us.
Just going to give folks a few moments to respond to the question. And remember, the feedback indicator is located on the left-hand side of your screen. So it does look like just over a majority of you chose yes, that this case would be prosecuted in your jurisdiction.
So there's a greater chance that that you guys have participated in an iLink webinar than you're in a jurisdiction that would prosecute this case. Okay, let's assume that Kenneth Douglas has been arrested and charged. So my first question for you is, as the prosecutor assigned to this case, what would you hope that the first responder within the correctional facility would do upon receiving a report of sexual abuse? And for this, we want you to use the private chat option to type in some answers. And so think about, some of your concerns that we as prosecutors have regarding evidence retention, intimidation, the ability to take statements from individuals. Take a couple minutes to type in your answers, and then Charlie's going to share some responses.
And remember that the private chat option, if you just click on my name and send your message, we'll be able to share those responses. So some of the responses that are coming in is that one thing that you would first start to do would be to seal the crime scene, and specifically mentioning the cell where the abuse had occurred. Other responses include obtaining the shirt that has the ejaculate, or getting a swab from the inmate's throat and mouth. Isolating the crime scene, again, is also another response. We've also got responses that say you should ask the victim if he was injured and refer or transport or walk him to the prison medical clinic. A couple more coming in. So that's the general gist of what's coming in right now.
Those are some really, really great responses, and one of the things that as prosecutors you can absolutely do in terms of making a difference in your jurisdiction as far as how these cases are responded to initially is you can communicate, and you should communicate, with your jurisdiction's confinement facilities to see how the first responder duties that are articulated in the PREA standards are being carried out and should be carried out in your jurisdiction, depending on the other support or criminal justice or law enforcement related agencies and responses that are available. And as we know, the very, very first response can be crucial in setting the stage for how the victim feels, about participating in our investigation and prosecution of the case, and certainly very important in terms of evidence retention. PREA standards contemplated this, and therefore the standards require that first responders separate the victim and the abuser, preserve and protect any crime scene until appropriate steps can be taken to collect any evidence, and if the abuse occurred within a time period that still allows for the collection of physical evidence, request that the alleged victim and alleged abuser not take any actions that could destroy physical evidence like washing, brushing teeth, changing clothes, urinating, defecating, smoking, drinking, or eating. So in our case, we would want to talk to our victim, Victor Jones, and the investigators to determine whether these protocols were followed and to what extent they were followed, as they could have a bearing on what evidence does or does not exist, as well as a bearing on Jones's ongoing willingness to participate in the prosecution of the case. Somebody had mentioned in response to the question we posed in the previous slide, the possibility of having that first responder walk Victor Jones down to the prison medical clinic. This is an example of something that hasn't been specifically articulated in a first responder duty. You as the prosecutor, if you're reaching out to the corrections facility to determine what's going to happen, what's going to be implemented as a result of PREA, this is something you might want to bring up. Ask, who would be responsible for transporting the victim? Perhaps this is not something that has specifically been contemplated by the confinement facility, and you could play an important role in helping them get that policy established. So what was done after the first responder learned of the incident? As most of us know, a SART or sexual response team provides support to a victim by allowing the victim to activate any or all of team members, including an advocate, a sexual assault nurse examiner, also known as a SANE, or other medical professional, law enforcement, and in some jurisdictions, a prosecutor. Regardless of whether the prosecutor is a member of the SART, we can contribute by helping to determine measures of support that would be consistent with prioritizing victim safety, as well as those consistent with preserving evidence in anticipation of trial. This slide addresses some of the PREA standards related to the SART. But the bottom line here is that the standards should be working to keep victims safe and help us get the evidence that we need. The standards require all corrections staff to be trained on prison rape and related requirements and procedures. So when a victim reports an incident, the person to whom it was reported should absolutely know that it should be reported immediately to the facility's pre-appoint person, and if that person is unavailable, to a shift supervisor, which is what occurred here. Since PREA standards require facilities to have a written plan to coordinate sexual abuse responder actions, it might be helpful for you as prosecutors to obtain that plan so that you have a framework for understanding the actions that occurred in response to a victim's report in the case that you have or that will occur in future cases that you get. Slide 19 contains additional information related to our case. So after Jones reported the sexual abuse, on Thursday, November 8th, at 9:30 at night, Jones was examined by a sexual assault nurse examiner at a local community hospital. The sexual assault nurse examiner noted in the medical records petechiae and redness consistent with that previously documented. STI and HIV prophylaxis provided. So does everyone recall our previous slide, slide 14, where we learned that approximately 12 hours after the sexual abuse, Jones went to the confinement facility doctor and reported a sore throat and pain in swallowing. And that physician, upon examination, noted petechiae to the soft palate and tonsillar pillars and some generalized redness. So what are petechiae? They're small red or purple spots caused by bleeding under and into the skin. Most likely, many of us have seen them before in various kinds of cases we've handled. We might have even had them ourselves. Significantly, it's likely that the first medical treatment provider may have noted an existing injury, like the petechiae, but probably would not ever have connected that injury with an incident of sexual abuse. Petechiae and redness would be consistent with a history of strangulation, although, as we know, Jones didn't actually present with that history. So we should keep in mind that very often an oral rape will yield absolutely no evidence, or perhaps a little evidence, although there possibly would be the petechiae that were found during Jones's examination. This is an example of something that you're going to want to ask the examining healthcare professional as well as an expert with whom you consult. Was this even looked for during the examination? Many times the answer will be no. You'd rather bring this out than the defense attorney. What evidence related to the medical examination potentially exists in sexual abuse cases? So this slide really for us addresses the difference between our expectations and reality. Please use the feedback option on the left to answer these questions in order. Question 1, if Victor Jones had been penetrated anally, what evidence would you expect to find? A, a tear in or injury to the anus, B, blood in or around the anus, or C, nothing.
Again, we're going to give you some time to answer that before sharing the responses. So a majority of the participants chose answer choice A, the second highest was C, and the third was B.
And question 2, if Jones was a female and she had been vaginally sexually abused, what evidence would you expect to find?
So for question 2, a majority of you chose answer choice C, with the second highest being answer choice B and the third being answer choice A.
So these are really interesting responses that the majority felt that for question number 1, a male who was penetrated anally, that there would be injury. And for question 2, it appears the majority felt there would not be, with a close second that there would be some bruising to the thighs or around her thighs. And here's what it was important for us to be familiar with, and that's when patients present with a history of sexual abuse, even abuse that is relatively promptly reported, as Victor Jones's was within 10 to 12 hours, the examination and collection will commonly yield no determinative, quote-unquote, injuries or evidence. And this is overwhelmingly the case for abuse that involves penis and mouth. And it is also true for cases involving penis and vagina, and to some extent, penis and anus. In Jones's case, evidence, as we know, may have disappeared through his eating, drinking, brushing teeth, or other activity. When we look at medical records, documentation from sexual assault, medical forensic exams, that documentation will often note that no injury was found to female genitalia or the anus. In cases involving female victims, a lack of injury is not inconsistent with a history of sexual abuse. As far as studies on penile penetration of a male anus, which we addressed in our first question, there are not many studies on this. But published studies have indicated that injuries are found more often in a male than a female victim. Of course, as we know, factors including lapse of time between the abuse and the examination, the details associated with the abuse could certainly impact the findings. So always, always, always speak to the examining sexual assault nurse examiner or physician as well as a medical expert to obtain information on the latest studies and get a sense of what that physician or sexual assault nurse examiner sees often in his or her exams in order to prepare for trial. You, of course, could also reach out to us at Equitas. This is an example of one of the issues, one of the many issues that we are happy to help you with in terms of trial preparation in sexual assault cases. What criminalistic evidence potentially exists in these cases? In other words, what do we need a lab to analyze for us? So in this case, we might be able to get DNA from a number of sources. Mouth from ejaculate, nose, cheeks from when Kenneth Douglas covered Jones's mouth and nose, the neck from the strangulation, although here, that's not a certainty because Douglas used his forearm. Floor from the ejaculate, Douglas's shirt, which we hope is not in the laundry. But we need to acknowledge most of this is unlikely, probably due to the passage of time or other contamination. Other people have touched these things. It's possible to get fingerprints from skin, but this is commonly not done by labs. So if you're interested in seeing if the fingerprints exist, you would have to specially and specifically request this from a lab in addition to a DNA swab. It also would be possible to get fingerprints from Jones's bed, but again, this could be unlikely for the same reasons. Still, as the government, we need to be looking for all of this because our jurors will certainly be wondering about these things. So even if it's not there, call a witness to explain that we looked for it and it wasn't there and that the absence of it is not uncommon. This is something that we do, as you guys know, all the time in our gun cases. We explain that finding fingerprints on a gun is extremely uncommon, and we explain why. We call an expert to explain this. We should be doing the same thing in our sexual assault cases. And if any of you want to share, before we move on to the next slide, if any of you want to share ideas or some suggestions for additional sources of potential evidence, please feel free to do that through private chats. And we'd be happy to inform the other webinar participants. So what are our other more traditional non-CSI sources of evidence, particularly because we know that so many cases involve a delayed disclosure? The possibility of obtaining criminalistic evidence may not be high at all. So we need to ensure that no stone has been left unturned. Who are our potential witnesses? We know who they are. They're cellmates, inmates in nearby cells, Officer Morrison, Shift Supervisor Gonzalez, the doctor from November 7th, the sexual assault nurse examiner from November 8th, the first responder. Who else? The fresh complaint witness. So the fresh complaint witness is a special evidentiary rule that applies only to sexual abuse cases that allows the prosecution to introduce the victim's out-of-court statements to another person, providing details that the abuse occurred. It's important for us to note, however, that the rule itself creates a little bit of a paradox, in fact, a large paradox. So while it's meant to help sexual abuse victims and it's meant to help us in our presentation of evidence at trial, it lends credence to the myth that a victim would, quote unquote, complain immediately, when in fact we know the opposite to be true in many cases. For 404B, look for other victims in and outside of prison. And to find them, we would want to look at Kenneth Douglas's criminal history, talk to neighbors or law enforcement in his home neighborhood who might have heard about other possible victims, talk to others in confinement who might be familiar with Douglas's actions and reputation. And finally, let's see if there are surveillance tapes. They might have captured Jones's and Douglas's actions and demeanors before and after the abuse, as well as other relevant behaviors like intimidation or maybe general bullying behavior from Douglas. And the question, of course, becomes here, well, what do we do if the prison doesn't have a camera? Well, we do what, think about what our jurors would expect, and you would want to call a witness from the facility to testify to the fact that the facility does not have a camera, because we don't want to leave our fact finders wondering why we didn't present this evidence. Character evidence. This can be very, very important in a sexual abuse prosecution, and we often overlook it. So under 404A2A, a defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. So as I said, we often overlook the importance of preventing or rebutting the defendant's admission of good character evidence by finding character witnesses to testify to the defendant's reputation for the opposite or lack of the relevant traits his character witnesses are testifying to. We should identify these potential character witnesses as early as possible. So have a very, very frank conversation with investigators explaining who these potential witnesses are and why we need to find them. And other ways we can do this ourselves, talking to staff and inmates regarding Douglas's reputation for being peaceful, law-abiding, or other traits that are deemed relevant in our jurisdiction. So question for you is, what facts would you argue to the judge in support of demonstrating Kenneth Douglas's level of dangerousness? And think back to the facts that we know of in this case. What specific acts or verbal threats would you articulate to the judge? These could be argued at any phase in support of a bail increase or withhold altogether, a separation order, etc. So please use the private chat option. And then Charlie will share some examples.
So to share some of the facts that have been coming in, the night attack and how brazen it was is one of the facts that was shared to talk about his dangerousness. The fact that there were other people present in the cell when the attack happened. That Douglas threatened the life of the inmate is also a fact to show his dangerousness. And that he tried to wipe away the evidence, and he did so using his shirt. So that shows a little bit about an indication that he's an experienced rapist who knows what he's doing. And
these
also
are really
share, I just wanted to share something that came earlier, talking about evidence that can be gathered. And one participant has shared that some facilities record phone calls from inmates that go out to families or other people who are beyond an approved list. And it's possible that that information can be gathered to talk about an assault that happened or will happen.
A lot of jurisdictions do that. That's a really great point and a great idea. And that's something that certainly the person who suggested it would know. But for the rest of us, that's something that we would want to flag immediately, that let the facility know that we want those calls recorded and turned over as soon as possible. And in terms of Douglas's dangerousness, we know that he's certainly sure of himself. He did not fear Victor Jones screaming or having anyone else in that cell intervene, even if they woke up in that small confined space. And significantly, we also know that he threatened Victor Jones with death. If you say a word, you're going to be dead by morning. So you already pointed out many important factors, but in assessing dangerousness, we also have to consider the research of what we know. And what do we know about most sexual offenders? We know that they have many victims. The majority are serial offenders. And Kenneth Douglas has already given us a few indications that he might be experienced in this area. So let's consider this in terms of his current and future threat. And regardless of whether the offender is an inmate like Kenneth Douglas or a staff member, when we investigate and considering that we're going to explain as part of trial the offender's predatory behaviors to our jurors, we need to keep in mind that some of them may be unique to confinement. Often we see sex offenders physically and emotionally isolating victims, but in confinement, this may be occurring on a whole other level. They may be grooming victims by befriending them, offering them rare or banned goods in a confinement facility. They may enter into a consensual relationship in which the victim comes to rely on the offender for certain things, or entrap the victim by covering up for a legal activity in prison or other activity that's banned in prison. And all of these acts of supposed kindness are really designed to exploit vulnerabilities and have a prospective victim let down his or her guard. What do we mean by coercion? Coercion is basically persuading someone to do something by using subtle or direct force or threats. It's extremely crucial for us as prosecutors for us to look into coercion, not only because it negates consent, but it's extremely important information in terms of our prep in the case and really being able to get a complete picture from the victim of what occurred in terms of the incident of sexual abuse and what occurred prior and after it. In prison, some inmates are in debt to other inmates. So in the past, these debtor-creditor situations were pretty much tolerated or ignored by corrections officers. So in other words, for example, officers were aware of situations where one inmate traded money or cigarettes for sex with another inmate. And if an act of sexual abuse was facilitated through a false trade or barter, this evidence would be extremely relevant not only to the defendant's method of committing the abuse, but also to show that the victim had no motive to fabricate, in that he would have lost out on the barter. So we've got to consider any suspicion that Douglas may be experienced, coupled with coercive behavior, and here certainly is verbal threat to Jones, as an indication that this situation is ripe for intimidation. In terms of victim selection, what do we know about Douglas's size and qualities as compared to Jones? We only know that Douglas is 28 and Jones is 19. It's possible Douglas attacked or felt he could get away with attacking Jones because he's younger, probably smaller due to the age difference, and possibly relatively criminally inexperienced. Anecdotally, we know predators may target youth, first-time inmates, inmates who are alone, inmates in debt, homosexual inmates, and inmates with mental illness. In fact, sexual abuse is 13 times more prevalent among transgender inmates than the general prison population. This slide has the PREA standards, which, in striving to prevent sexual abuse, include 10 criteria to be considered when assessing inmates for risk of sexual victimization. So the bottom line here is we should take time in our prep to analyze how the defendant planned and controlled where, when, and how the attack occurred, so that we can explain it to jurors. We should also explain, if it's applicable, that our defendant looks for a target who would present the least resistance and be too intimidated to report it. Do not leave it up to our jurors and fact finders to surmise all of this on their own. So what victim behaviors have you encountered that were viewed as challenging in a sexual abuse case? So use that private chat option to Charlie and share some behaviors that were challenging in a case that occurred in or out of confinement that you or one of your colleagues prosecuted. In these trials, we need to be realistic and openly confront and embrace the things that we may initially believe pose challenges in our presentation of evidence to fact finders. And we can do this through voir dire to determine potential juror biases and belief in rape myths and misconceptions. A huge challenge. Oh, I'm sorry, Charlie. Did people respond and you want to share?
Yes, we have a couple of responses that I was going to share with you guys.
Go ahead.
So a pretty consistent response that's coming in is the reliability of inmates in general at the trial. Also included is some things about piecemeal disclosure, a lack of physical evidence or evidence to corroborate the victim. Additionally, recantation, where the victim hangs out with the offender after the incident of sexual abuse, calls, and then also we've got one of the prosecutors who commented added that he or she had combated this by calling an expert to testify about common victim behaviors when thinking about hanging out with the victim, recantation, and disclosure, and that continued contact with the offender is a common behavior.
These are excellent, and these are all things that can and should be addressed in your closing argument. And when you address them, use other real-life analogies to explain these common victim behaviors, as well as the great suggestion, of course, utilizing an expert. So on this slide, we just wanted to bring out some things that may be really challenging for fact finders. The fact that a victim is or was an inmate may be challenging, and then a fact finder may think that he deserves to be victimized. Jurors may also have a difficult time understanding victim behavior after the assault, and they could use that behavior to blame the victim for the abuse. And some of those examples are lack of active resistance, not crying out or remaining silent, delaying a complaint, seeking medical attention for something other than sexual abuse, and washing away any evidence. And of course, a significant challenge is the I don't care mentality, a fact finder who just doesn't care at all about what happens in prison, thinks that that's where other people who've done bad things go, period, and I just couldn't care less. And obviously, do what you can during voir dire to weed out jurors who are going to have a challenge overcoming these biases that they are presenting with when they show up for jury duty. Assessing victim credibility. This is a must for our own internal analysis of a case, but it also contains the framework for what we just mentioned in the previous slide, the closing argument, which we as prosecutors should start thinking about the minute we start prepping a case. In a closing, we've got to embrace credibility. We need to tell the jury why our victim is credible and believable. Tell them that this is a case that is about accountability and credibility, and here is how they should assess credibility. So that the next 5 things on there are how to assess credibility. by detail, recount every single detail of the abuse through every witness and piece of evidence. Focus on those different kinds of details that provide the ring of truth. And this can be anything from what the victim was thinking about or doing during the assault. Even a thought like, the last time I saw my mother, we got into a fight, just something. To small things that the victim changed about his life or his daily routine in the aftermath of the abuse. I had a case once with a victim who started wearing a belt every day after she was sexually assaulted. And obviously, that wouldn't happen in prison. They're not allowed to wear belts. But she also started wearing 2 pairs of pants to sleep every night. And that's a detail that, of course, was not in the discovery and that I never would have known about but for having a very frank and long conversation with the victim. These are the kinds of details we need to be asking about. Focus on the victim's and the offender's demeanor before and after the assault by talking to the victim and any other witnesses, and explain demeanor during any medical examination statement, and then explain to the fact finders that demeanor can be expressed in many, many different ways, from a flat affect to absolute hysterics, to laughing. Some of us laugh when we get nervous. Interest means motive. What possible motive could this victim have for fabricating sexual abuse? So you should note any possible reason and then turn it around 180 degrees. Don't rely on the defense that the defense attorney is presenting, because one of your jurors may have come up with another defense on his or her own. So any possible reason, flip it around. Explain that because the victim reported the abuse, he, for example, has now been labeled a snitch, has had to switch his cell, is constantly fearful that others will find out that he has been raped. Any repercussion he has faced. Any example like that. Describe why facts that you presented, that were presented by the government, are the facts that make sense because they're the truth. And then pick apart why the defense's version of the case makes no sense at all. Take notes during the opening, very important. And if you can't do it, bring an intern or someone else into court who can, and remind jurors of what the defense said would or would not occur during the trial. And, of course, include every single piece of evidence, statement, et cetera, that corroborates the victim's testimony. But at the same time, keep in mind that corroboration is not necessary to prove that an assault occurred. As someone mentioned earlier, working with experts is crucial. Significantly, do not polygraph the victim. In order to be eligible for Violence Against Women Act grants, an agency or official cannot request or require that a victim of sexual abuse submit to a polygraph as a condition of proceeding with an investigation, and PREA standards also include this rule. And finally, we need to be fighting defense attempts to introduce irrelevant evidence, such as, the bad, quote-unquote, character evidence regarding the victim. Anything that will help the defendant divert attention from himself and place the focus wrongly on the victim. So we should utilize Rules of Evidence 412 and 404A2B to help us in excluding this irrelevant evidence. So victim safety, this is a prosecutorial must. It's got to be considered first and foremost, and obviously it has a direct effect on our ability to seek justice and prosecute. So what should we do? First, request a standing separation order for confinement, transport, and the courthouse, with serious consideration given to whether to keep the victim and the offender in the same facility. Safety has to be the preeminent consideration when we're deciding to transfer either the victim or the offender, because we've got to recognize inmate networks are vast, and information about inmates in one facility can become known to inmates in any facility. So in addition to separation from the offender, the victim should be separated from any of the offender's allies where possible to reduce the potential for intimidation and retaliation. We should also heed the PREA standards, which clarify that inmates shall not be placed involuntarily in protective custody unless an assessment of available alternatives has been made and a determination has been made that no other alternative means of separating the inmate from the abuser exists. So as the prosecutor, this is also something you should have a meaningful discussion with the victim and corrections facility staff about. Protective custody really could have a negative effect on our victims in terms of isolating them and obstructing their participation in helpful, educational, vocational, therapeutic, and other opportunities. So if we carefully construct our separation orders, we can ensure that our victims have continued access to programming and services, which could be particularly essential after suffering the trauma of sexual abuse. Charlie, did you want to add something here?
Sorry about that. So it looks like there's a helpful comment that was posted related to pretrial conditions, suggesting talking to the victim to make sure that he has things to occupy his time, that there's an outlet so he's not sitting in prison thinking about the abuse, making sure that there are books, magazines, other distractions for the victim.
So that comment clearly, thank you, Charlie, has come from someone who has handled a case of sexual abuse in confinement or something similar, and a prosecutor has taken that extra step to support the victim, and that's a great suggestion. What options do prosecutors have if Jones is unavailable as a witness at trial? I want to note that this question focuses on a straight analysis of admissibility due to witness unavailability. And later in a future webinar, we're going to discuss the witness's unavailability due to the wrongful actions of the defendant or one of his associates. But for today, this is a straight analysis of admissibility due to the unavailability of a witness. Please use the feedback iLink option and tell us which is the best or most likely option here. A, withdraw prosecution. B, analyze our statements and evidence to determine whether we can proceed. Or C, arrest our victim and put him on the witness stand.
Just giving everybody an opportunity to answer the question. So the answers have been fluctuating back and forth a little bit, but it looks like a majority of you, almost all of you that responded, chose answer choice B, analyze statements, evidence, and other witnesses to determine whether we can proceed without Jones's testimony. And no other participants chose other responses.
That is really, that's terrific, because the answer to this question is really, it depends. And it depends in large part on an analysis based on the following line of cases, starting with the case that we hear so much about, Crawford v. Washington. And I'm going to try to quickly go through this case law, but this is an area where, once again, we really encourage you to ask some questions. Crawford v. Washington was not a domestic violence case. Defendant Crawford stabbed a man who allegedly tried to rape Crawford's wife, Sylvia. Crawford was charged with assault and attempted murder, and he claimed self-defense. Washington state's marital privilege bars the spouse from testifying without the other spouse's consent. So at trial, of course, Crawford invoked the marital privilege, thus preventing Sylvia from testifying. At trial, the prosecution introduced a recorded statement of Sylvia made during police questioning as evidence that the stabbing was not in defense. Crawford argued that admitting the evidence would violate his right of confrontation under the Sixth Amendment. The trial court admitted Sylvia's statement because it had sufficient indicia of reliability. And this reliability determination was based on the court's old test articulated in Ohio v. Roberts. That was a 1980 case that was the leading case at the time. The state Supreme Court upheld Crawford's conviction, deeming the statement reliable. The U.S. Supreme Court, held that the state's use of Sylvia's statement violated the Confrontation Clause because where testimonial statements are at issue, only confrontation can satisfy constitutional demands. In other words, nothing else is reliable. That's what the Supreme Court was telling us. In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So, what is our ultimate question? Our ultimate question, is a statement testimonial? If yes, the witness must testify, as the reliability of statements can be tested only through cross-examination of the witness. Or the prosecution must show that the witness is unavailable. And as we all know, what deems a witness unavailable, what constitutes unavailability varies in jurisdictions. And there must have been a prior opportunity to cross-examine the witness. If the statement is not testimonial, then it's not covered by the Confrontation Clause, and it's left to the states to decide admissibility. So, start thinking about Victor Jones's statements to various persons and whether they were testimonial or non-testimonial, and what arguments you would make to support the admission of certain statements. And I think that this slide 34, is a great helpful slide. I would print it out and bring it into court, because when you're at the bar of the court and you're getting faced with questions and arguments from the defense attorney, from the judge, it's really helpful to be able to look down and see this chart. So while Crawford did tell us that where testimonial statements are at issue, only confrontation can satisfy the Constitution, Crawford did not really spell out what was considered testimonial. We leave for another day any effort to spell out a comprehensive definition of testimonial. And for any of you who want to look that up, Crawford was authored by Justice Scalia, and this particular quote appears on page 68 of the opinion. However, 2 years later, two cases were decided together, Davis v. Washington and Hammond v. Indiana, that did provide guidance. Davis v. Washington was a domestic violence case in which the victim called 911, identified the defendant as the assailant, and described the assault to the 911 operator. When the victim called 911, the defendant had just left the scene. The victim did not testify at the defendant's trial, but the trial court admitted the 911 tape. The defendant was convicted. The state Supreme Court affirmed the conviction, holding that the 911 call was not testimonial and not the equivalent of an in-custody police interrogation. And thus not subject to the Confrontation Clause. It also held that the purpose of the 911 call is to call for help and not bear witness, and therefore is not testimonial. Let's look at Hammond v. Indiana, the second case decided in that joint opinion. Hammond v. Indiana was also a domestic violence case in which the police responded to a crime scene, or at least to a scene. They didn't know that definitely a crime. And the victim then described to them, there was a crime. This is how the defendant assaulted me. The victim did not testify at the trial, but the law enforcement officers testified to her statements. The trial court admitted the statements under the excited utterance exception to hearsay. The defendant was convicted, and the Indiana Supreme Court affirmed the conviction, reasoning that the statements were not testimonial because the officers questioned the victim in order to assess and secure the situation, not to preserve the victim's statements for future use in a legal proceeding. What happened? Well, the United States Supreme Court upheld Davis v. Washington. They upheld that the 911 statements were not testimonial and thus not subject to the Confrontation Clause and thus not subject to a Crawford analysis. But the U.S. Supreme Court overturned Hammond v. Indiana, holding that the victim's written statements in an affidavit to police were testimonial and thus subject to the Confrontation Clause. In Hammond, there was no emergency in progress, the court reasoned, because the crime was over. When we look at these cases, the holding is that police interrogation, the takeaway is that police interrogation is testimonial if circumstances objectively indicate, one, there was no ongoing emergency, and two, the primary purpose of the interrogation was to establish or prove past events potentially relevant to a later criminal trial. And police interrogation is not testimonial if circumstances objectively indicate there was an ongoing emergency and the primary purpose of the interrogation was to address that emergency. So what's an emergency? Right, everyone's like, how do I define an emergency? This is another example of a very important word that we should not assume everyone has the same definition of. An emergency occurs when we need to end a threatening situation. And it's not just a threatening situation to the victim, but it's a threatening situation to police and to the public. It's very important for our finders of fact, for our judges who are going to be ruling on motions regarding our efforts to get statements to be admitted, of what actually constitutes an emergency. Well, the U.S. Supreme Court provided us with further guidance in the case Michigan v. Bryant. This is a case that was decided in 2011. In this case, police responded to a radio dispatch of a man who was shot. Police found the victim with a gunshot wound to the abdomen, in great pain and having difficulty speaking. The police asked him, what happened to you? Who shot you? Where did the shooting occur? And the victim was able to identify the shooter and generally the circumstances of the shooting. He said the defendant shot him outside of the defendant's house and that the victim drove himself to the gas station parking lot where the police found him. Within hours, the victim died at the hospital, and at trial, the officers testified to what the victim said to them in that gas station parking lot. What did the Supreme Court do, guys? Well, thank goodness they held that the victim's statements were not testimonial because the primary purpose was to enable police to meet an ongoing emergency. So this case, Michigan v. Bryant, reaffirmed the primary purpose test and directed the use of an objective evaluation of case circumstances to determine the primary purpose of a statement. This case clarified that the existence of an ongoing emergency is among the most important factors to consider, but not the only factor. And finally, the court explained that the statements and actions of both the declarant and the interrogators provide objective evidence of the interrogation's primary purpose. So what are our takeaways from this line of cases? Crawford, Davis, Hammond, Michigan v. Bryant. Number one, when the primary purpose is to address an emergency, then the statements are not being given with the intent of creating a record for trial. And thus, they are non-testimonial, not within the scope of the Confrontation Clause, and don't trigger Crawford. The primary purpose should be assessed objectively from the perspective of the parties at the time of the encounter. So in other words, number two, would a reasonable person believe that there was an emergency at the time? This goes back to what we said a couple minutes ago. It's very important to clarify all of this on the record, leaving no stone unturned for the judge to guess any of these things. The more detail you can provide, the better. And one other thing I want to share about Michigan v. Bryant is the court actually pointed out that one of the very relevant factors in its determination that there was an ongoing emergency was actually the chaos and the disorganization that occurred with law enforcement. So normally when we hear that things got a little messy when police responded to a crime scene, we are like, oh my gosh, guys, we need to present this in a way that makes sense, that is a timeline, who responded to what. But actually, in terms of determining whether statements were given and there was an ongoing emergency, a little bit of police chaos is extremely helpful in that determination. So that's certainly something that you want to ask the officers about. Hey, guys, girls, what was it like out there? How was everybody feeling? Were people walking around frenetically? Did it seem as if you were addressing this and addressing that and people were running around looking for the offender? Chaos is helpful in the analysis. So remember, if the statement is non-testimonial, Crawford does not apply, but our state hearsay rules do. And if the statement's going to come in, it has to fall within an exception. So our question for you, which of Jones's statements are most definitely testimonial, meaning, objectively speaking, they were given under circumstances where there was no ongoing emergency, and thus the primary purpose of the questioning or the statements was to establish or prove past events potentially relevant to a later criminal trial. So each letter on this slide has two statements next to it. We've included statements that you as the prosecutor would potentially learn about at a later date or would find in your discovery. These are the normal statements that would be part of a sexual abuse and confinement case. Use the feedback option now to select A, B, C, or D to indicate which statement would be deemed most likely testimonial and thus subject to a Crawford analysis if Victor Jones was not available as a witness at trial. So A, Patrick Morrison and the prison physician. B, Tony Gonzalez. He was the shift supervisor who took the report. And a police detective or a special victims unit detective who would have responded from the jurisdiction's local or county police. C, the sexual assault nurse examiner who examined Victor at the outside healthcare facility / hospital, and a friend or a fellow inmate whom Victor Jones confided in. And D, an advocate and a friend called on the phone.
So we're just waiting for a few more answers to come in as you guys get a chance to read over those and think back on the discussion of testimonial statements from Vicki. And it does look like the majority of you chose answer choice B, Tony Gonzalez, an SCU police detective. The second highest choice was D, advocate and friend called on the phone, with the fewest number of you choosing answer choice B, same, at outside facility and friend fellow inmate.
Most likely, the answer is B, Tony Gonzalez, and a responding police detective and or special victims unit detective. And that's because based on the case law, those statements will most likely be determined to not have been made during an ongoing emergency, and the court will probably find that they were made to establish past events potentially relevant to a later trial. But as for the other statements, there absolutely could be arguments on both sides, depending on the circumstances under which each statement was given. So prosecutors should talk to Jones to determine his state of mind at the time the statements were given, and also talk to the people who were either asking questions or to whom the statements were given. What were they thinking about at the time? What did they do in response to receiving the statement or the information? These things are absolutely relevant to determining whether there was an ongoing emergency at the time and or whether the statements were made to establish past events and anybody was thinking that they could potentially be relevant to a later trial. And another question for you, our final question for you. Would a prosecutor, would you have a difficult time prosecuting the case against Kenneth Douglas without the participation of Victor Jones? Please let us know by using the feedback option.
So it looks like an overwhelming majority of you chose yes, that you would have a difficult time prosecuting the case without Victor Jones's participation. One of you did say no, so that's at least promising. I also want to encourage everyone listening, if you have any questions for Vicki, you can private chat them to me and I'll pass them along for our question and answer session.
I love that somebody said no. I think that's great, and I think that that prosecutor is a prosecutor I would love to work with and learn some strategies from. I think, given the existing case law and the direction in which the case law seems to be going, both in federal courts and in our state courts, that we would have a very difficult time prosecuting this case without the participation of Victor Jones. And really what that tells us is that our ability to support Victor Jones from the very outset by working with multidisciplinary professionals, so that means us, police, advocates, medical professionals, corrections professionals, it's not only crucial to his safety, obviously, but it's crucial to keeping him as a participant in the trial and the entire criminal justice process so that we can hold Kenneth Douglas accountable and make sure he doesn't rape anybody else. So in summary, PREA, the Act and the standards, have helped increase our awareness and understanding of the importance of preventing, detecting, and responding to sexual abuse and confinement. The standards and the protocols have provided a framework for best practices and accountability within corrections facilities. But we as prosecutors are ultimately responsible for ensuring that these cases are prosecuted to the fullest extent of the law while ensuring the victim is safe and supported. So we should reach out and work with our other allied criminal justice professionals to prioritize the investigation and prosecution of all sexual abuse and work collaboratively to ensure that those who are involved in the detection and response of these cases understand the extent and the needing of evidence and witness identification and retention and collection, that we understand effective victim-centered, offender-focused prosecution strategies, and other practices that enhance victim safety and protection. If we all work together, we can continue to work toward eradicating sexual abuse and confinement and bring offenders to justice. Does anyone have any additional questions for us? Sorry, Charlie, go ahead.
Oh, I was just going to say, if you do have additional questions related to this webinar, you can ask them now. You can also submit them to us via the Contact Us page on our Equitas website, and you can reach out directly to Vicki as well, directly through technical assistance. Just waiting to see if we have any questions coming in now.
If anybody has any PREA or standards-related questions, Tara Graham is available to answer those questions as well. Oh, okay. Somebody asked, what can prosecutors actually do to make sure that prisons are following these standards and safeguarding evidence for cases? That's a really great question. And you as an individual can take proactive steps. So talk to your supervisors and other leaders within your office to see if there is a contact person or persons in your jurisdiction's corrections facilities, some of which may already have a pre-appoint person. Reach out to the Department of Corrections in your state in addition and see what PREA standards are already in place. And then have a phone call, have an in-person meeting with the contacts in these confinement facilities and discuss the standards. Offer to them, what can we do to make things more streamlined when you as the facility receive a report and vice versa. There should be an open discussion so that these cases are handled in more of a streamlined fashion and in a meaningful way with an investigation that's going to yield some useful evidence. If anyone has additional questions, we'd be happy to answer them anytime, and you can certainly email us after the webinar directly.
So here's a question for you, Vicki. Have you found a part of the country leading the way in prosecuting these cases? It's a tricky question.
I think that is a tricky question. We have not heard specifically of a jurisdiction that is leading the way. However, we have heard from many prosecutors who have handled these cases, and we have also heard from other prosecutors who are working in jurisdictions that are not taking these cases. I can tell you from my personal experience that we had many of these cases that were brought to our attention in the Philadelphia District Attorney's Office. And if you are interested in getting more information about a specific jurisdiction, we would be happy to work with you to get that information. Tara, have you heard of anything specifically related to a jurisdiction?
Tara, are you on the line? Okay, so if Tara jumps in, then I will stop talking, but if not, I just wanted to share with you guys a couple of additional resources. You can see them on the slide that's up here, including the U.S. Department of Justice's National PREA Standards, a link to those, a strategies newsletter written by Vicki on prosecuting cases of sexual abuse and confinement. Also some prosecutors' resources that talk a lot more about Crawford that was addressed earlier in the presentation, also go into information about forfeiture by wrongdoing, which I'm sure that she mentioned. Okay, and then the last resource is Voices for Justice, Surviving Prison Rape. produced by Just Detention International, and that link will get you there. They also have a lot of other great resources on their website. And Tara, are you there? So I did get a chat from Tara letting us know that she hasn't heard of any leading places in the nation yet. But if that information comes to light, I'm sure that we will be sharing that in the subsequent webinars following this one. Also, here's Vicki's information, as well as some more information about the Pre-Resource Center. And I'd like to first thank our presenter, Vicki Christensen, and all of you in attendance for your participation and dedication to increasing victim safety and offender accountability in your communities and across the country. Just so you know, this webinar was recorded, so if you're looking for any information or follow-up, you can access that via the iLink website. You'll get an email with a link to access that recording. You'll also receive an email with a link to the PowerPoint presentation as well as Vicki's biography. And so when you exit, when you exit iLink, you're going to be sent to SurveyMonkey to fill out a survey about the webinar today. And then if you want to visit equitasresource.org, you can register for future webinars and training events and review additional information about Equitas. And please remember that Equitas is a 24/7 technical assistance provider available to respond to your questions and concerns and training needs as they relate to prosecution and violence against women. On behalf of Equitas and the Pre-Resource Center, thank you so much for your participation in today's webinar.